My name's Jonathan Adler. I'm a professor here at the law school and director of the Center for Business Law and Regulation. And I'm pleased to welcome you back for our panel on districting and apportionment dispute, the political question doctrine as applied to election disputes, including Bush versus Gore. This is a timely panel. As some of you may know, the Supreme Court is actually hearing a political question case, albeit one that arises in a different context, next Monday. So we will hopefully be getting some guidance on the current scope of the political question doctrine, the extent to which it applies. It's also an appropriate issue to be talking about here at Case Western, because as one of our panelists will discuss, we have some very live Bush v. Gore related disputes going on here in Ohio. And I think it's probably fair to say that we will have more of them to come in the future as well. We have a great panel to address this topic. I'm going to introduce them very briefly. Their full bios are in the packet of materials, so please refer to that if you want to know more than what I'm going to tell you. But first, we will have Nelson Lund, who is the Patrick Henry Professor of Constitutional Law and the Second Amendment at George Mason University, where he was also Vice Dean, co-editor of the Supreme Court Economic Review, and had previously served in the offices of the Solicitor General, the Office of Legal Counsel, and as Associate Counsel to the President. After Professor Lund, we will hear from Daniel Takagi, who's Professor of Law at Ohio State University. He's a prominent blogger on election law issues, co-author of a prominent election law casebook, co-editor of the Election Law Journal, and still manages to find time to occasionally dip his hand into election law-related litigation of various sorts here in Ohio. And then after him, we will hear from Candace Hoke, who's Associate Professor of Law at our neighbor down the street, Cleveland Marshall College of Law at Cleveland State University, a director of the Center for Election Integrity, and was a member of the ABA's Advisory Commission to the Standing Committee on Election Law, and is also quite active in election monitoring and the like, which is often the precursor to election disputes, or at least hopefully helps us avoid election disputes. But with that, I will turn it over to Professor Lund as our first speaker for this panel.
Thank you very much. I have 3 points that I'll argue for very briefly. First, Baker versus Carr and its early progeny were wrongly decided. Second, in light of the doctrine generated by these decisions, Bush v. Gore was correctly decided. And third, even without Baker and its progeny, the holding or the decision in Bush v. Gore would still have been legally correct. Baker versus Carr inaugurated a wide-ranging reform of legislative apportionment. Justice Frankfurter worried that the court was risking its legitimacy by intruding into politics, and he doubted that this political reform could be effected using a judicially manageable legal doctrine. He was soon proved wrong. The very next year, the court promulgated a simple rule, one person, one vote, that it was able to apply without too much difficulty. But if we take a closer look at Baker and its early progeny, a somewhat different critique emerges from the dissenting opinions of Justice Harlan. In Baker, he offered a straightforward legal objection. The majority failed to explain why it was reversing the lower court's dismissal of the complaint for failure to state a claim upon which relief can be granted, and he cited Rule 12b-6. Harlan's argument had 4 main points. First, there is no general constitutional principle requiring equipopulous districts, as the U.S. Senate proves. Second, such a requirement had no basis in our legal tradition or in the legislative history of the 14th Amendment. Third, the court had repeatedly and recently rejected challenges to unequal districts. Fourth, Tennessee's apportionment plan easily survived scrutiny under the applicable rational basis test for violations of the Equal Protection Clause. Brennan's majority opinion completely ignored all of the evidence about the original meaning of the 14th Amendment. It sought to distinguish the numerous precedents upholding unequal districts by reading them very narrowly. But what about Harlan's crucial argument, namely that the plaintiffs could not in any event prevail under existing law? Here is Brennan's entire analysis of that question. Judicial standards under the Equal Protection Clause are well developed and familiar, and it has been open to courts since the enactment of the 14th Amendment to determine, if on the particular facts they must, that a discrimination reflects no policy, but simply arbitrary and capricious action. Now, as Professor Sakharov pointed out, there are no cites in here, but that doesn't mean that there were not well-developed and familiar standards. They were aptly summarized by Justice Harlan in his dissent, and I'll read that. All that's prohibited is invidious discrimination bearing no rational relation to any permissible policy of the state, citing Williamson versus Lee Optical. And in deciding whether such discrimination has been practiced by a state, it must be borne in mind that a statutory discrimination will not be set aside if any state of facts reasonably may be conceived to justify it, quoting McGowan versus Maryland. Brennan made no effort to refute Harlan's argument that the Tennessee Apportionment easily survived this standard. Tennessee, as we know, had not reapportioned its legislature for 60 years, during which urban areas had experienced faster population growth than rural areas. In Harlan's view, the legislature could rationally have decided to refrain from reapportionment in order to preserve a desirable geographic and demographic balance and to foster governmental stability. Even if the legislature had expressly sought to protect the state's agricultural interests from being overwhelmed by the sheer numbers of city dwellers, that would no more violate the Equal Protection Clause than tax statutes that favor agricultural interests. I think this is a straightforward application of standard rational basis review, and the analogy with tax statutes shows why cases involving racial or religious discrimination were irrelevant. Brennan's casual disregard of Harlan's legal arguments indicated that the court's detailed effort to find only narrow and distinguishable holdings in the precedents was little more than a smokescreen. That indication was confirmed in the next three major cases, which came in short order. Within 2 years, the court announced a novel one-person, one-vote rule and applied it in slightly different versions to statewide elections, to congressional elections, and to state legislatures. In each case, Harlan showed that the decisions had no basis either in the Constitution or in any other kind of law. Confident of its prerogative to create new law, reflecting a new vision of democratic governance, the majority treated Harlan's legal arguments with disdainful silence. When you read the opinions, I think it's easy to understand this silence. Harlan so thoroughly demolished the majority opinions that one can hardly imagine what response could have been offered. Now, whatever one thinks of the Warren Court's democratic theory or of its cavalier attitude toward the law, one would think that the doctrine of these cases would be regarded as settled after nearly 4 decades of acquiescence by the court and the public. That's certainly what the majority in Bush v. Gore thought. They saw the case, quite correctly, I think, as a straightforward application of the principle that emerged from Baker versus Carr. That principle, as the court was soon to formulate it in Reynolds versus Sims, is simple and intuitive, which no doubt helps to explain its durability. Here's what Chief Justice Warren wrote in Reynolds. Weighting the votes of citizens differently by any method or means, merely because of where they happen to reside, hardly seems justifiable. One must be ever aware that the Constitution forbids sophisticated as well as simple-minded modes of discrimination. The fact that an individual lives here or there is not a legitimate reason for overweighting or diluting the efficacy of his vote. This is the clear and strong command of our Constitution's Equal Protection Clause. Now, the Florida Supreme Court decision that Bush v. Gore reviewed was shot through with vote debasement that affected citizens differently because of where they lived. It was also very sophisticated in the sense that it was complex enough to be somewhat obscure. The Florida court may not have been motivated by a desire to discriminate against certain classes of voters or to favor one of the presidential candidates, but it certainly did violate what Reynolds called the clear and strong command of our Constitution's Equal Protection Clause. The Florida court ordered a paradigmatic form of vote debasement, similar in effect to stuffing the ballot box, which Baker versus Carr and all of the next three cases had used as an example of illegal vote dilution. In the Florida election, one candidate had narrowly lost the race, as determined both in an initial count of the ballots and in a recount, both of which were tabulated primarily by vote counting machines. The Florida court ordered a revision of vote totals based on hand recounts in a few counties strategically selected by the losing candidate because of his party's dominance in those jurisdictions, and conducted by local officials who had been chosen in partisan elections. The court even ordered that votes be definitively added to this candidate's total from a partial recount in one county that had begun with precincts that historically favored his party and had never reached the precincts that had historically favored the other party. The Florida court also ordered a selective recount in Miami-Dade County that would include only the ballots selected by the losing candidate, and a selective statewide recount of the same kind of ballots that this candidate had selected in Miami-Dade. The recounts had used different counting standards, and at least one county had repeatedly changed its rules in the course of the recount. The partial statewide recount was to be performed without any uniform standard for distinguishing valid from invalid ballots, and contemporaneous objections by the candidate's representatives were disallowed. Now, even assuming that every vote added to the totals correctly adjusted a mistake by the vote counting machines, a heroic assumption, but even making that assumption, voters in different places were being treated very differently. There is no meaningful difference between stuffing the ballot box with invalid votes and selectively adding valid votes to the final total. The court-ordered recount was at best a somewhat less egregious version of a recount in which mistakes favoring one candidate are corrected and mistakes favoring the other candidate are ignored. 3 of the 7 judges on the Florida Supreme Court protested that this utterly bizarre recount order violated both Florida law and the federal Constitution. And a majority of the Supreme Court, the U.S. Supreme Court, agreed. They agreed that it violated the federal Constitution. I think the most troubling feature of Bush v. Gore is that it was not unanimous. 2 justices, however, could find no violation of the Equal Protection Clause. Justice Stevens refused even to look for a violation. Why? Because finding one might call into question other election practices that were not before the court, and because, and here I'm quoting, the interpretation of constitutional principles must not be too literal. We must remember that the machinery of government would not work if it were not allowed a little play in the joints. Now, I think that's a remarkable response both to the facts of the case and to the legal analysis set forth in the majority opinion. And it's one that could be used to reject the holding in every one of the court's seminal one-person, one-vote decisions. For her part, Justice Ginsburg claimed that there was no substantial equal protection claim because the Florida hand recount might be no worse than the previous machine counts. Now, why she would think so is anyone's guess, for no constitutional challenge to the machine counts have been raised in the litigation, and no evidence of equal protection violations in those counts had been presented. If there were any legal basis for Ginsburg's legal conclusion, it would apparently have to rest on her invocation of Williamson versus Reapportionment. That, of course, is the very case that Justice Harlan cited for his claim that Baker versus Carr marked a dramatic departure from prior law. Now, as it turns out, I think even Reapportionment does not support Ginsburg's conclusion. And to see why, it's helpful to focus on a distinction which has not attracted much attention between Bush v. Gore and other vote dilution cases. Previous cases involved legislative actions that had a perfectly plausible rationale, or executive actions that violated statutes enacted by legislatures. Bush v. Gore was extraordinary because it involved an election practice so bizarre that no legislature would ever even think of adopting it. And I think it's no accident that the closest analogs in the case law involved criminal behavior by executive officials. The recount in this case was designed by a court, an institution with special obligations to refrain from arbitrary actions and to explain the actions it takes. Unlike any of the apportionment decisions, the Florida recount order failed even the extremely forgiving rational basis standard that Justice Harlan rightly thought was applicable in Bush versus Carr. Under that standard, the Equal Protection Clause prohibits discrimination bearing no rational relation to any permissible policy of the state and does not prohibit discrimination if any state of facts reasonably may be conceived to justify it. The Florida Supreme Court majority tried to identify rational relations between the various elements of the recount order and the permissible state policy that elections should be determined by the will of the voters rather than by strategies extraneous to the voting process. That was the permissible state policy that the Florida court articulated. That policy, however, cannot possibly explain the actual ruling. That ruling was based on a very different policy, which was never stated in the opinion, and which was pretty much the opposite of the stated policy. The real policy went something like this. Once the ballots have been counted by machine, we will allow the loser to strategically choose which ballots to re-examine by hand, and we will accept any changes that result from this recount. But because that would so manifestly allow the outcome to turn on strategies extraneous to the voting process, we will also direct the trial court to make an effort to perform a slightly less selective recount than the loser had demanded. Making the recount slightly less biased than what the losing candidate wanted cannot possibly serve the legitimate policy of ascertaining the will of the voters of Florida. To do that, you would have to design a recount that could plausibly be thought to be more accurate or more reliable than the initial machine counts. The statewide recount ordered by the Florida court applied only to so-called undervote ballots, which are those on which the machines detected no vote for any candidate. Why were they chosen? Because the losing candidate had asked for a recount of undervotes in one county. But why did the Florida court not order a statewide recount of overvotes, namely ballots on which the machines detected a vote for more than one candidate and therefore recorded no vote? Once one determines that the intent of the voter should always be honored, even when the voter failed to comply with the instructions on how to vote, these two categories of ballots become logically indistinguishable. Furthermore, the need to treat undervotes and overvotes the same way is only the most obvious requirement of a recount aimed at determining the will of the voters. If one were actually serious about designing a recount that was more accurate than the machine counts, one would also have to recount all of the ballots identified by the machines as legal votes. Whatever criterion were adopted for changing undervotes to legal votes, the presence of hanging Chad or dimpled Chad or whatever standard, that same criterion would have to be applied to ballots containing both a machine-readable whole and a hanging or dimpled Chad. That means that some legal votes would have to be changed to overvotes and thus deducted from the vote totals. This could have been quite significant for ballots containing both a clean whole for one candidate and a dimpled or indented Chad for another, were quite common in the Florida election. Thus, the Florida Supreme Court could not possibly have been seeking to ascertain the will of the voters of Florida. Instead, it was seeking to ascertain the will of a peculiar subset of Florida voters, namely those who had cast undervote ballots, along with those other voters who both happened to reside in the counties Gore had strategically selected for full recounts, and who happened to reside in precincts where such recounts had actually been conducted. This series of choices by the Florida court was at best patently capricious. When reviewing legislation under the rational basis test, courts often imagine or hypothesize legitimate reasons for the law. And that makes a lot of sense because legislatures need not, and frequently do not, explain why they chose to act as they did. Courts are different, and the Florida court in particular gave reasons for its decisions. But the complete disconnect between the actual decision and the permissible state policy it was purportedly implementing exposes the utter irrationality of the Florida majority's reasoning. There's no need to make an effort to imagine a rational basis for the recount order because the judicial opinion shows that none existed. That conclusion is simply reinforced by the fact that no legislature ever has, or likely ever would, provide for such an extraordinarily biased recount. Thus, even if Baker versus Carr had never given birth to the one person, one vote doctrine that made Bush v. Gore an exceedingly easy case, the Supreme Court's decision in the Florida election case would still have been correct under the standard law of equal protection. Baker versus Carr is widely revered, often by the same people who see Bush v. Gore as something like the crime of the century. Both views are wrong, but the second is doubly wrong. The Supreme Court's decision was compelled by Baker and its progeny, but it would have been legally correct even without those precedents. In one sense, however, the outrage against Bush v. Gore, I think, does have deep roots in the court's one-person, one-vote decisions. Both are based on an intense and unshakable urge to conflate the rule of law with what Justice Harlan called a political ideology. The dissenters in Baker versus Carr may have underestimated the court's ability to pull off its program of political reform, but they did not misunderstand its fundamental betrayal of the law. Perhaps the most important legacy of Baker is reflected in the passionate and widespread denunciation of Bush v. Gore for refusing to repeat that betrayal. Thank you.
Well, thanks to the Case Western Reserve University Law School and Law Review for having us all here today. Despite the title of this panel, Redistricting and Reapportionment, this is actually the panel where I think nobody is going to talk about redistricting, at least not much. I am going to talk, like Nelson, about Baker and Bush. This panel may also be exceptional in that it features two people who have at least a partially favorable view of Bush versus Gore. But let me start with Baker. Its most obvious importance in the many dimensions to the case, which Professor Zakharoff described, its most obvious importance is lifting the barrier to judicial involvement in redistricting through its redefinition of the political question doctrine, which set the stage for extensive federal intervention, including intervention by the courts in the drawing of districts. We might call this series of developments the partial federalization, at least, of redistricting. What I'm going to talk about is the broader impact of Baker versus Carr, as well as Bush versus Gore, in making the federal courts important players in the electoral process. Call this the federalization, or at least the partial federalization of American elections. My particular focus here is going to be on the federal judiciary's increasingly important role in the years since Bush in what's generally referred to as election administration, by which I mean the set of issues that have come to the fore since 2000, including voting machines, voter ID, provisional ballots, voter registration, things that really weren't on the radar screen of the general public or even most election scholars before then. Before 2000, election administration was almost exclusively a matter of state law and local practice with a very limited federal overlay. Today, there is a much greater federal involvement, including involvement by the federal courts. Now, to understand the partial federalization of American election administration during the past decade, it's necessary to talk not only about Baker, but also about Bush versus Gore. And at the risk of hyperbole and with some caveats, I'm going to suggest that Bush can be understood as the new Baker, insofar as it set the stage for federal courts, especially lower courts, to play a much more active role in policing the administration of elections, just as it did, just as Baker did, with the redistricting process decades earlier. This is exemplified by a piece of remarkable litigation that I'm going to discuss in southwestern Ohio, involving an obscure state judicial race, but one which brings to the fore a not too subtle struggle for power between federal and state courts over the authority to decide. So I'm going to divide my remarks into three parts, which we might term Baker, Bush, and ballot boards. First, Baker, and why I think, among other things, Baker needs to be understood as a case that is about federalism. Second, Bush, and how it's played a comparable, if not exactly equivalent, role in election administration. And third, this under-the-radar power struggle between federal and state courts, which I anticipate to be of increasing visibility and importance in years to come. So Baker was just as important for what it took away as for what it gave. What it took away is one of the main justifications for the political question doctrine that had existed in prior decades, namely respect for state sovereignty. And it's in this sense that I mean that Baker was at least partly about federalism. It was about the relationship between the federal and state governments. It opened the door, of course, to federal courts policing the redistricting process, an area that was formerly reserved for state legislatures and state courts. It's useful, in order to see this, to go back to Baker's famous formulation of the various factors that define political questions, starting with a textually demonstrable constitutional commitment of the issue to a coordinate political branch, a lack of judicially discoverable and manageable standards. I won't go through the other four. What I want to emphasize here is that these factors, as defined in Baker, are about separation of powers, not about respect for state sovereignty. That's what's missing from Baker's list of factors. Now, to see how this was a change in the law as it had existed before Baker, it's useful to go back to the case, one of the cases that Professor Zakharoff mentioned, Luther versus Borden. I don't need to go back through the facts since you've already heard them. What I want to emphasize about this dispute arising from Rhode Island over which government was the legitimate one is a dimension that wasn't really mentioned in Baker's discussion of Luther or its redefinition of the political question doctrine. I mean, it's certainly true that Luther was partly about separation of powers in the sense that it was reserved to the political branches to determine which of these Rhode Island governments to recognize. Therefore, the courts didn't need to enter into it. But if you actually go back through and read the Luther opinion, a lot of it is about federalism. It says, for example, court in the Chief Justice Taney's opinion, the courts of the United States adopt and follow the decisions of state courts in questions which concern merely the Constitution and laws of the state. The power of determining that a state government has been lawfully established is not one of the federal court's powers, and so on. It goes on like this for several pages, concluding the authority and security of state governments do not rest on such unstable foundations, before getting to the moreover, which is where we get to the discussion of separation of powers, which is how Luther comes down to us today. So Baker, while I, in contrast to Professor Lund, agree with its result, it was engaged in some sleight of hand in redefining the political question doctrine and taking federalism or respect for state sovereignty off the table as a justification for applying it. Now to Bush. By taking respect for state sovereignty off the table, Baker set the stage for the federal judiciary's much more active involvement in the redistricting process. The story that I want to focus on here is not about redistricting, but about how something similar has happened in the realm of election administration in the last 10 years. Just as we can divide redistricting into the before Baker and after Baker eras, we can divide election administration, I think, into the before Bush and after Bush years. In the after era, there's a substantial federal footprint in this area, and specifically active judicial superintendents of election administration. And so it's in this sense that I suggest Bush may be understood as the new Baker. Now, a couple qualifications here. First, I'm not talking about citation counts, right? It's been widely noted that the Supreme Court has studiously avoided citing Bush versus Gore in the years since then. One commentator has called it the Voldemort of election law, the case that must not be named. Second, I'm not talking about the intent of the Supreme Court when it decided these two cases. The Baker Court was quite conscious of the fact that it was opening a door, whereas the Bush Court seemed intent on, to the extent possible, shutting the door behind it. There is the famous two sentences, there are the famous two sentences from Bush, would have been widely criticized, I think somewhat unfairly, but let me read them. Our consideration is limited to the present circumstances, for the problem of equal protection in election processes generally presents many complexities. The question before the court is not whether local entities in the exercise of their expertise may develop different systems for implementing elections. Now, some commentators have criticized these two sentences for being unprincipled. I don't agree. What I think the court was doing here is something that it actually does fairly routinely, which is to articulate a general principle, in this case a fairly established one, and apply it to a new area, election administration. It's certainly true that election administration hadn't generally been considered a subject for this principle of equality, drawn in part from the one-person, one-vote cases that Bush states, but I don't think this statement is all that remarkable. And in fact, there's a similarity to the one-person, one-vote cases, most notably Reynolds. A friend of mine, Paul Moki of Wilmington College, not long ago gave me, was at the Library of Congress, and gave me a copy of Chief Justice Warren's notes from Reynolds versus Sims, which is 7 pieces of paper on which he's got listed 34 points, which formed the basis for his ultimate opinion. Point number 1, there can be no formula for determining whether equal protection has been afforded. Point number 20, cannot set out all possibilities in any given case. And this kind of language actually made it into the opinion in Reynolds, where, for example, the court says, for the present, we deem it expedient not to attempt to spell out any precise constitutional test. Developing a body of doctrine on a case-by-case basis appears to provide the most satisfactory means of arriving at detailed constitutional requirements in the area of state legislative apportionment. So I think there is a similarity even here between Bush and the one-person, one-vote line of cases. Now, what I think is most important in terms of the similarity between the two is this assertion of federal judicial power, which arises in part from a distrust of the states when it comes to running elections. And while the Supreme Court has avoided citing Bush like the plague since it's come out, that doesn't mean the case has been without an impact. I'm going to quote from Professor Zakharoff a line from one of his earlier articles that I love. Bush versus Gore declared that federal courts were open for business when it came to adjudicating election administration claims. This is a perfect way of putting it. Lower courts relaxed justiciability barriers, heard cases, especially cases filed in the weeks leading up to an election on an expedited basis, put them on the top of their dockets. And some of this, at least, is quantifiable. My casebook co-author, Rick Hassan, has documented in a series of articles how the number of election challenge cases has gone up over the last several years, from 108 in 1996 to 197 in 2000 to 361 in 2004, down slightly to 297 in 2008. Same for midterm elections. Most important for my purposes, more of this litigation is taking place in federal courts. At the start of the last decade, 80% of these election cases were filed in state court. By 2008, that number was down to 54%. So Bush versus Gore didn't just judicialize election administration, it federally judicialized election administration, at least in part, moving much of it from state to federal courts. So now to ballot boards. I think it's a good thing. I think it's a good thing that federal courts are more actively policing election administration. I've given the argument elsewhere, so I'll just summarize it here. The reason I think it's a good thing is because federal courts, while certainly not perfect, are more insulated from partisan politics than any other institution, at least than any institution that exists in most of the states, including state courts. We in the United States are an outlier in the sense that we don't have an election authority, a federal election authority, that is insulated from partisan politics, as most other advanced democracies and even some relatively nascent democracies do. And we, of course, in most of our states have judges who are either elected, sometimes as nominees of their party, or are at least subject to retention elections, and therefore face a sort of conflict of interest, I'd argue. Let me close by talking about this one case down in southwestern Ohio, the Hunter-Painter litigation, which I think is a fascinating example of this under-the-radar struggle for power. This is a case that involves an election for juvenile court judge in Hamilton County in the Cincinnati area between the Democratic candidate Tracy Hunter and the Republican candidate John Williams. So the Board of Elections finds that Williams, the Republican candidate, has won by 23 votes. It bases this decision in part on the counting of 27 votes that had been cast early at early voting, but cast in the wrong precinct, right? There aren't actually precincts that you physically go to for early voting, but you cast a ballot that is of your precinct. Well, 27 people cast wrong precinct ballots and were still counted, but a much larger number, some 849 people who went to the wrong polling place or were directed to the wrong polling place on election day, didn't have their votes counted. Hunter files a federal lawsuit saying that this is a violation of equal protection. In response, supporters of Williams, the Republican candidate, go to the Ohio Supreme Court, which is 6-1 Republicans. So the Ohio Supreme Court basically sides with Williams, but what's really interesting is what it says, right? the Ohio Supreme Court makes this assertion of, hey, this is our turf. The United States Constitution, it says, leaves the conduct of state elections to the states. It goes on to say, we are not bound by rulings on federal or statutory or constitutional law made by a federal court other than the United States Supreme Court. And finally, it issues an order that purports to limit the kind of re-examination and investigation of these wrong precinct ballots can go on. Now, in response to this, the case goes back to federal district court. Judge DeLotte issues an order, without getting in too much into the details, requires some of those ballots to be counted, requires an investigation of others. The Sixth Circuit upholds her order, saying it is not for the state court to resolve equal protection claims previously filed and still pending in federal court. The en banc petitions, if you go back and look at the en banc petitions that are filed by Williams, the Republican candidate's supporter, they're all about the respective authority of state versus federal courts. It begins with this assertion: the panel has made the district court the final arbiter of whether a particular ballot will be counted, contrary to Ohio law and the functions traditionally performed by state and local officials, that this intrudes into the power of states and their handling of federal, state, and local elections. Now, the Sixth Circuit has rejected the petition for a rehearing en banc. Case went back down to the trial court, the federal district court, Chief Judge DeLotte, down in the Southern District of Ohio. There's been a trial and we're awaiting decision. It seems to me quite possible that this case is going to go back up, and quite conceivable that the Sixth Circuit could grant en banc rehearing, depending on what happens when this decision comes back up. So the big point I want to make, using this as an example, is that while this is an unusual case, right, rarely is the tension between federal and state courts more apparent. It is representative of this increasing, growing battle for turf, and a battle for turf that I think the federal courts, by virtue of their greater insulation from partisan politics, should win.
I'd like to begin with a few stories. First, I'm a refugee, so to speak, of Ohio's election system. I was actually the very last witness present at the Cuyahoga County's 2004 presidential recount. And it was surprising to me, in part because it was a punch card election. I had been teaching Bush versus Gore. I expected it to be simply a punch card election. And I discovered, as the very last person there, a fact that doesn't seem to find its way into Bush versus Gore or other punch card decisions, and that is the fact that the punch card tabulators actually fed their results into a Windows-based PC. Now, that doesn't sound all so bad, does it? Except that after all the other witnesses had gone home, and I was waiting for the printout to carry to the various political parties who had requested the recount, a print was made. The election officials looked at it, and they had banished all the witnesses from the tabulation room when they were printing. They looked at it, went over to the computer, made some changes, reprinted it. Looked at it again, made some changes, reprinted it. 45 minutes later, multiple prints, none of which they would give me, nor would they answer questions about what they had been doing over at the computer. They present with a big smile the printout of the presidential recount. So I'm about to talk to you about the role of software in elections and what we might need to be thinking about as lawyers when we seek to protect individual rights, but also, hearkening back to what Sam was saying, our systemic rights as a democratic republic. We don't seem to be understanding the role and the vulnerabilities of software and software-based technologies. Let me recount a few other examples. There are just legion. South Carolina, you remember the strange Senate primary for the Democratic Party, where someone who was a complete unknown happened to win or be announced as the winner. It was very difficult to find enough voters who said that they had actually voted for him. There were lots of different arguments about how it could happen. It was not challenged. But the League of Women Voters and working with computer scientists asked under public records laws for copies of, or the actual ballots, which they audited. And not only in that race, but also in 2010, other 2010 elections, they have found a systematic pattern in South Carolina of hundreds of votes not being counted, and of hundreds, actually 1,400 votes in one election, in excess of the number of voters who actually were registered and signed in at the polls. The election was certified anyway. The audit occurred after certification. Pima County, Arizona, a challenge to the electronic results occurred a good while after a public, sort of a bond issue was on the ballot, and it was thought that the election did not have the announcement that was expected. And some individuals met one of the computer operators at a bar, and he reported what he had done. Where were the tallies? How were they controlled? They were in a private room, one person, no observers, and yes, the capability of being able to change votes. Now, one point that we know of as a result of some of the computer science studies is that the software manufacturers, meaning the voting system vendors, actually designed these systems without engaging any computer scientists who were computer security specialists. They included such features as an erase button for audit logs, so that election officials could actually go into the system, right, without any special moves, and erase their activity. Why would we ever want any election officials or anyone to have the capacity to erase the tracks of what occurred in the tabulation? Further, lots of this software does not report when all votes have not been tallied, or when there are ballot batches or memory cards that have been uploaded multiple times. So these are design failures. Then we also have very poorly written software, which computer scientists of extraordinary note from Princeton, the University of California, Stanford, et cetera, have studied and have reported that it is very, very low quality, so that it is riddled with bugs. It's been proven not to count accurately. And this is the technology that we are using to assure fundamental rights to vote. So picking up from Dan and from Sam, we do need, it would seem, judicial involvement. But what's the response? I hope to convince you in this very quick talk that voting tech offers another avenue or tool for insulating electoral incumbents, but also that this mechanism is more insidious and dangerous than redistricting because of the nature of current software. That the members of the political branches generally either misunderstand these dangers and ridicule them openly, or potentially understand but choose to leave the openings, the vulnerabilities in place for the opportunity that could be exerted to rig elections. To to my final conclusion is to realize and protect the fundamental constitutional right to vote, be it federal or state, and our rights to democratic self-government. We need the judiciary to step up when asked, to adjudicate rather than to defer to the political branches. And I would bet you are not surprised to hear that the judiciary has, by and large, been expressing various excuses for not policing voting technology. For instance, there have been 3 cases filed under state constitutional law relatively recently, or at least adjudicated relatively recently. The one in Texas was filed by the NAACP. The Texas Supreme Court just ruled this summer, yes, an equal protection claim will lie, but sadly enough, the choice of voting technology has been allocated to the Secretary of State. She didn't find a problem with using all electronic elections technology with no paper records whatsoever to be able to check and to audit the technology. So sorry. There are 2 others that are pending right now. One is in New Jersey. New Jersey actually has, and a law school, a Rutgers Constitutional Law Clinic, has been litigating this case since 2004. It did go to trial, was sort of a battle of experts, but there's only one computer scientist with no security expertise who testified, but the judge credited his approach. When I talked with him privately in his office, his approach was, if you think about hackers, they're much more valuable targets than elections. I mean, if you were a capable hacker, wouldn't you choose to go after financial institutions rather than elections? Those of us who are concerned about redistricting should or know the history of elections and efforts to influence, potentially improperly, elections, can poke holes in that argument. But in his view, it was not an economically rational approach. Of course, hackers can be paid, but there's also the problem of this incredibly flawed software from the design stage all the way through the implementation. So, in each of these cases, the state defendants claimed that the decision rests with the political branches, that it's a complex calculation of trade-offs and technical decisions unfit for courts. I would agree, to some degree, that courts should not be making technical decisions as to which technology to order. That's where I disagree with one of my colleagues, but I do believe that they are capable of deciding which technologies cannot deliver on the promise of an accurate vote, each ballot being accurately counted. And in particular, we need the courts, I would argue, to add to our understanding of what the fundamental right to vote means, and to require in this software period that it requires that every vote be accurately tabulated and tallied in a way that can be proved. Not that it's secret, not that we are required as a voting public, as a democratic republic, to simply trust that the machines are accurately counting. We have proof they frequently aren't because of inadvertent problems. We also have proof, some even from our state, where there has been some intrusions. We have proof in other locations as well. And in New Jersey, just a few weeks ago, there was an election, again, for a local office, very small, but I think there were maybe around 25 votes. The candidate who expected to win did not. So the candidate went out and asked people in the neighborhood, did you vote for me? Got a list of votes. It seemed to accord almost perfectly with the number of votes that the opponent received. So he filed suit. Enter the Rutgers constitutional law team again, and Andrew Appel of Princeton, who has been very much involved in these cases as a forensics expert as well as a computer security expert. And the court ordered that the records of the election be preserved for his evaluation. The day before he arrived 2 hours later at the location to review the computer files and discovered that the day before, all the records on the computer had been erased. This is in violation of a court order for preservation. We don't know what happened, but indeed there was a desire to stop the investigation. So, what are we going to do? Are we going to have courts step up or not? Let me just quickly move through some other points. We do have the capability of requiring as a public through our regulatory system that the software be written in a way that is what we call high assurance. So far it has not been. It's been written at a very low level. We could require, either judicially or through the regulatory system, audit logs that cannot be erased. And by the way, the software manufacturers have even embedded in these systems that the audit logs need not even be turned on. So there's no evidence that as to how the tabulations may have been affected. And many other points as well. We need to understand that the contracts that keep the voting system vendors alive are the technical service contracts, and those are contracts that are let by politically affiliated officials. So there is a kind of conflict of interest that's embedded. Now, they also do not fully understand the risks, I should say the political branches, officials, and the election officials. For instance, Washington, D.C. was going to run an internet voting apparatus for their overseas military and civilian voters in 2010, and after requests for a public test, they did allow it, and within just a few hours, a team from the University of Michigan, without any knowledge of the election officials, took complete control over the server, was able to change 100% of the ballots, wrote in science fiction write-in candidates for every single race. Further, they left code to change every single ballot that came in thereafter. They also discovered that there were probes from China and from, seems like North Korea. So they wrote code to block those countries, those probes, from being able to affect the elections. And they found other materials that included all of the personal records of all of the voters of the district. So the election officials did not know, and it wasn't except for the team deciding to leave an indicator that the election officials discovered several days later. Now again, this was planned for a federal election, and the election officials kept professing their great confidence in their convenience opportunities for overseas voters and military voters. But they did not understand the capability of offering basically an illusory ballot. And that's the situation that we're in, not only for internet voting, but also for even the existing election equipment, unless we think very carefully about the principles embedded in election law that protect the right to vote, but were created in a paper-based world. We have not rethought how to modify and update these principles to protect voting rights in a software world. And it is an extraordinary change that we must address. Otherwise, we could have elections as nothing more than theater, and that is a systemic concern. So without going further, I look forward to changes in the electoral regulatory system. I'm very hopeful. My article will develop more of that, and I'm hopeful that we will have more litigation at both the federal and state levels, but we need an informed judiciary and better principles to protect our right to vote from the software vulnerabilities. Thank you.
We have a little bit of time for questions if folks have questions. Again, as before, please make your way to one of the microphones if you do have questions for any of the panelists. I don't know if any of the panelists want to take a moment or two to comment on each other's comments
I'd rather
first,
just go to the
or
audience.
folks rather just go straight to questions, then there we go. Questions for the panelists? We can have a shy crowd again.
I'm shy, but I'll try. I guess for Professor Lund, in Baker, why was the state apportionment entitled to rational basis review when it was claimed to have a disparate impact on the basis of race?
I don't believe that, I read this decision fairly recently, and I don't remember anything in the opinion saying that the apportionment was being struck down because it was racially discriminatory. But maybe there's something there that I'm not remembering or overlooked when I read it.
Well, would you approve of Harlan's dissent indicating that it passed rational basis review? Is that a fair assessment of?
I don't know what other standard would have been used, and neither did Justice Brennan, which why there were no cites in his opinion on this point.
Well, wasn't it entitled to a heightened scrutiny?
No, why?
Scrutiny on the basis of a disparate impact on race?
I don't know what the basis for that would have been. What case would that have been based on?
Well, my memory is that
Racial discrimination, by the way, under the Equal Protection Clause, it requires a finding of illegal racial discrimination under the Equal Protection Clause requires a finding of intent, not just disparate impact. A lot of cases subsequent to this that have held that.
If I might chime in here, I mean, I agree with Professor London, at least in part. The one person, Baker and the one person, one vote cases are not expressly about race discrimination, but about how malapportionment affects the political power of people in different geographic areas of the state. I mean, at least that's what the cases say they're about, and in particular, as was noted earlier, how people in overpopulated districts, which tend to be predominantly in urban areas like Memphis, were underrepresented. Now, there's some evidence that the racial impact of malapportionment was at least on the court's mind at the time that it decided these cases. I know Morton Horowitz has written something about this. So I do think that is part of the background, but it's true that it wasn't part of the actual decisions.
in Bush, would the outcome have been different if Florida had ordered a statewide recount under a uniform standard? And what about the remedies? Why did they terminate the recount in order of certification of the results? Couldn't they have allowed the recount to continue in a manner not violative of the Equal Protection Clause?
Well, first, if they had ordered a statewide hand recount of all the ballots, I don't think there would have been any equal protection problem. That never could have been accomplished within the time available, but there wouldn't have been any equal protection problem. As to the remedy, what the majority said was that they remanded the case with language in their remand order that would have allowed the Florida Supreme Court to order a constitutionally valid recount. Again, there was no prospect that that could possibly be done, and Vice President Gore, presumably realizing that, did not ask the Florida Supreme Court to do that. But the remand order allowed the Florida Supreme Court to order a constitutionally valid recount.
Oh, it did?
It certainly did.
Let me start with that. I don't think that's accurate. If you actually go back and read the Bush versus Gore opinion, it's pretty clear that the Supreme Court did not contemplate that. To the contrary, it indicated that it thought that given that they were at the so-called safe harbor date, the recount had to end. I think the remedy is the part of Bush versus Gore that is most questionable. I actually tend to agree with its conclusion that there was an equal protection problem, a conclusion shared by 7 of the justices. But I think what the court should have done is remanded with instructions for the Florida, well, remanded in a way that allowed the Florida Supreme Court to determine whether, as a matter of Florida law, the recount should proceed, or whether it had to end on the so-called safe harbor date, the date that Bush versus Gore came out. That's the decision, whether to comply with the state harbor date, that is left to the states and their legislatures. On the first question you asked, if the Florida Supreme Court had done that from the beginning, right, had instead of having this vague intent of the voter standard, which wound up being implemented in different ways in different places, if it had said, well, a vote should count if 2 corners of the chat are punched, but not if only one is punched, for example, I think the United States Supreme Court would almost surely have said that that is a violation of Article 2 of the Constitution, insofar as it's for the state legislature and not the state courts to define the rules according to which presidential electors are chosen.
Let me just respond on the remand point. The majority in Bush v. Gore recognized that it would have been illegal to instruct the Florida court to conduct some different kind of recount, because the Florida court a day or 2 before that had held as a matter of state law that time was up that day, the so-called safe harbor date. The Florida Supreme Court had held as a matter of state law that the time was up, and therefore it would have been illegal for the United States Supreme Court to order them to violate state laws they had held. Now, what the Supreme Court's remand order did was permit, without encouraging, the Florida Supreme Court to overrule its decision from a day or 2 before and create more time under state law. The remand order allowed them to do it. It certainly didn't encourage them to do it, but it did permit them to do that.
Would there have been an Article 2 problem if the state Supreme Court had then gone back and said, oh, we were just kidding, the safe harbor doesn't matter, the legislature didn't want to take advantage of it, we misread the law and had overturned their opinion? Would that then have created a worse Article 2 problem?
It might well have, but the United States Supreme Court didn't base its decision on Article 2. The whole Article 2 argument has certain advantages and certain disadvantages over the equal protection holding. The Article 2 argument is the one that was advanced in the Rehnquist concurrence. It has advantages and disadvantages. I mean, I'd have to sit back and think for a while before I start speculating about what if they had done that and then what had happened, and all kinds of counterfactual hypotheticals.
Thank you.
Thank you. Another question?
Thank you very much. It was fascinating. This is for Professor Hoke. Fascinating presentation. I'm a professor of political science at Baldwin Wallace College, and it's rather frightening for me to think that this is happening on perhaps a systemic basis where we have this kind of a software problem. A couple of questions. Number one, how do we know it when we see it? Politics is a funny thing, and oftentimes elections are even stranger, their outcomes. And second off, if it is a systemic problem, where do we start?
Excellent questions. Thank you for them. How do we know it? One of the problems is that we have election officials who have not been trained in how to detect when an incident, be it inadvertent or deliberate, has occurred, and they've not been given the tools and the software has not been written to be able to flag it. And the documentation also does not educate. It's as if we have required election officials to use technology that basically throws a tarp over the entire process. They don't know what's happening under the hood. under the TARP. And we also do not have in place the updating of our legal rules. For instance, there is a federal statute dating to the early 60s, before the Voting Rights Act, that requires the preservation of all records pertaining to a federal election for 22 months. But that's not been updated in light of software-based, meaning that the elaboration of what is required to be kept by these election officials in all jurisdictions, so that they are throwing away or not keeping various kinds of records that are required. So one is to, and I'm trying to work with DOJ to encourage them to engage in some of this updating. We probably need to have great people like Dan and others who are excellent litigators and understand the voting technology risk to voting rights to work on updating our existing standards for what are the actual contours of the right to vote that can be enforced through courts when there is a question about the election technology. I would rather see more of this technology invalidated, and also that as part of the record-keeping requirements under this federal law, that all that software has to be hard-coded for keeping all the records, that they cannot, it's not a matter of choice by an election official or a staffer as to whether it's going to log properly or at all. We have to have those records, and then we have to understand the limitations of the software. Florida, for instance, already in retrospect, because of their Bush versus Gore experience, they now require for their recounts that only the memory cards can be re-uploaded to check the totals. Even though they required now to have paper ballots under state law, the paper ballots cannot be checked as against the totals and have that be the legal ballot. They require only the memory cards, which basically insulates the process. Another example of why we need federal courts involved who are cognizant about the risks of software, and we have a long way to go. So the regulatory system, DOJ, and the courts.
Thank you very much.
If I might ask you a question, Candace. So, you know, I tend to share your view that this is one of the areas in which it's good for federal courts to be acting as at least the policeman around the corner looking over the shoulders of state election officials. The real hard question is, boy, what to do about it? I mean, you know, it's been a while since I've looked over all these reports on the security vulnerabilities of various voting systems. But at the time that I was looking over this, including some reports that came out of Ohio, you know, all these systems are software dependent, and all of them have some problems. So it's not as simple as ordering that you stop using touchscreen machines and go to precinct count optical scan. And this is what I think is the real hard question for federal courts. If they find that there's, or state courts, if they find that there are some serious problems here, what's the appropriate, how do you remedy that?
Well, one short-term remedy would be to require not only auditability, but also not software-based auditability only, but actually a independent record of the voters' choices that can be independently tabulated, basically, through a hand count and matched against or checked against the machine counts in the tabulation. When we see flaws, we have to understand that there are a variety of possible sources, but that the paper ballots that are voter created would be the legal ballot record. And that is the rule in Ohio, but it's not the rule, for instance, in Florida.
Of course, we've had a lot of problem with our paper ballot records, especially here in Cuyahoga County. Right?
Yes, we have, but the other thing, too, is that we do have statisticians who are working assiduously to develop the models that will allow the fewest number of ballots to be counted at a 99% level of confidence as to whether the election was actually tabulated accurately. We have to have that check on the software. It's a systemic check. It's one that can occur so long as we have an independent paper ballot. We cannot have software-only elections Otherwise, we leave open this huge possibility of the inability to determine whether the election was actually honest and every vote was accurately counted.
We have time for one final question before our break, is it? Right?
Yeah, I just have a quick question about that. My understanding is that before I was born, they used to use like physical machines and they would punch holes out of them. And in those machines, they would probably have like a key lock that someone could access, and that even at the Pentagon, the locks are only supposed to be unbreakable for 8 minutes, and then less than 8 minutes, someone walks around and sees the door, because any lock is vulnerable to being picked. And my understanding of computer security is that with physical access to a machine, I don't care what kind of things you do to it and what kind of software security is, it can be rooted and it can be taken over and the facts can be erased. I understand not allowing them to go on the internet because that's just, asking people to do it without physical access. But how is this any different than the old problem, and how is it solved by any other way than just having, independent people watching the machine to make sure no one's touching it? I don't understand how it's a unique problem to software.
There's a whole lot there. It's valuable. The most important point is that you understand that the physical security is critical and that software-based machines don't solve the old problems. And that really was the aspiration of Congress when it created HAVA and funded all of this new technology. The belief really was that the problems of sort of tampering or human judgment as to what is a valid vote would disappear. It would become this universally neutral system that we could trust. And of course, we can't get there because there's so many human judgments all along the way, from the writing of the software, the design and writing of the software, all the way through the tabulation and reporting, with just possibly thousands of different ways to affect the count. So once we understand, and you do, that software-based technologies are not the answer, at least right now, then we can start talking about, so what do we need to do to protect the count and the accurate, I'll just leave it there.
So I actually think the basic intuition of your question is exactly right. Look, you look back at the history of paper-based ballots, we got a lot of problems with those. And if you look back at the history books and cases involving actual proven allegations of cheating, they're almost all involving paper-based systems. Now, I do think that Ken is absolutely right that software introduces a different set of problems that is maybe analogous to, but not exactly the same as those that we've experienced before. I just think, look, software is with us here to stay when it comes to ballot. And maybe, I don't know if we disagree on this point, but it's not going away. So the two big things that I think we have to do as a policy matter are get better software in place and get better procedures in place for implementing these systems once they're there. Now, it's really easy to say these things as general propositions. Accomplishing it and figuring out the details is really hard.
Well, please join me again in thanking our panelists.